Hello, myself Vikrant Singh, and today our topic of study is contract of indemnity and contract of guarantee. So, what is indemnity? An indemnity is a contract by one party to keep the other harmless against any loss. And what is contract of indemnity? A contract of indemnity as per section 124 of the Indian Contract Act 1872 is defined as a contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person is called a contract of indemnity. The key fundamentals of a contract of indemnity are: it is a promise to compensate for or security against damage, loss or injury, and in wider sense it includes all contracts of insurance, guarantee, and it is not a collateral but an independent contract. It is a tool for allocating risk, contingent liability. Indemnity clauses, amongst other things, must be clear, specific, where possible stipulate the circumstances under which the indemnity will arise, be considered in light of any exclusion of liability clauses found elsewhere in the agreement, and state what damages will be payable in the event of the clause being successfully evoked. So the enforcement of the contract of indemnity also depends on various factors. The enforcement of contract of indemnity depends upon the following factors, such as a contract of indemnity can be enforced according to its terms. Claim of indemnity holder can include damages, legal cost of adjudication, amount paid under the terms of compromise, and the measure of damages is the extent to which the promises has been indemnified. Indemnifier should ideally be informed of the legal proceedings or should be joined as third party. There is no onus to show breach or actual loss. Indemnity contract includes two parties, namely the first one is indemnifier and the second one is indemnity holder. The person who is promising to pay compensation is called indemnifier, and the person who loses is compensated is called indemnify holder. Section 125 of Indian Contract Act defines the damages on the breach of contract of indemnity. The definition is as follows: the promisee in a contract of indemnity, acting within the scope of his authority, is entitled to recover from the promiser all damages which he may be compelled to pay in any suit in respect of any matter to which the promise to indemnify applies, all costs which he may be compelled to pay in any such suit, if in bringing or defending it he did not contravene the orders of the promiser, and acted as it would have been prudent for him to act in the absence of any contract of indemnity, or if the promiser authorized him to bring or defend the suit. All the sums which he may have paid under the terms of any compromise of any such suit, if the compromise was not contrary to the orders of the promiser and was one which it would have been prudent of the promises to make in the absence of any contract of indemnity, or if the promiser authorized him to compromise the suit. In common law, indemnity was established in the case of Adamson versus Jarvis. The plaintiff and auctioneer sold certain cattle on the instruction of the defendant. It subsequently turned out that the livestock didn't belong to the defendant but to another person, who made the auctioneer liable, and the auctioneer in turn sued the defendant for the loss he had thus suffered by acting on the defendant's direction. The court laid down that the plaintiff had having acted on the request of the defendant was entitled to assume that if what he did turned out to be wrongful, he would be indemnified by the defendant. The Law Commission of India, in its 13th report 1958 on the Indian Contract Act, has recommended the amendment of 124 According to its recommendation, the definition of the contract of indemnity in section 124 expanded to include cases of loss caused by event which may or may not depend upon the conduct of any person. It should also provide clearly that the promise may also be implied. The second one is contract of guarantee. A contract of guarantee as per section 126 of the Indian Contract Act 1872 is defined as a contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. The person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. A guarantee may be either oral or written. The key fundamentals of a contract of guarantees are: a contract of guarantee is a contract to answer for the payment of some debt or the performance of some duty by a third party who is primarily liable for that payment of performance. It is a collateral contract which does not extinguish the original obligation for payment or performance. It is rendered null and void if the original obligation fails. The liabilities of a guarantor in law depend upon those of the principal debtor, and when the principal's obligations ceases the guarantors to do, except in certain cases where the discharge of the principal debtor is by the operation of the law. In some guarantees, the consideration is entire. For example, in consideration for a lease being granted, the surety becomes answerable for the performance of the covenants of the lease. In other cases, it is fragmentary or supplied from time to time, as where a guarantee is given to secure the balance of a running account at a bank for goods supplied. When the consideration is entire, the guarantee runs on through the duration of the lease and is irrevocable. When the consideration is fragmentary, unless the guarantee stipulate to the contrary, the surety may at the time terminates its liability at the guarantee. Guarantee contracts include three parties, namely creditor, principal debtor, and surety. The person who granting the loan, the person who is utilizing the amount of loan is principal debtor, and the person who is giving guarantee is called the surety, guarantor or favored debtor. In case of guarantee contract, there will be two types of liability, namely primary liability and secondary liability. Primary liability will be with principal debtor and secondary liability goes to surety. The surety becomes liable when the principal debtor commit default meeting the liability. Surety has the right to sue the third party as a principal debtor directly. The law puts him in the position of creditor. Anything done or any promises made for the benefit of the principal debtor may be a sufficient consideration to the surety for giving the guarantee. The guarantor needs not personally derive any benefit from the guarantee. The liability of the surety is coexistent with the of the principal debtor. Unless it is otherwise provided by the contract, the creditor can straightway proceed against the guarantor without first proceeding against the principal debtor. The liability of the surety can never be greater than that of the principal debtor. The surety can, however, may restrict his liability to part of the principal debtor liability by contract. Surety liability is distinct and separate. I hope this video helped you in understanding of the contract of indemnity and contract of guarantee.